So we are gonna continue now with the. We are gonna continue now with the first roundtable session, roundtable discussion of the workshop. And before I give Yahli the floor to chair and moderate the discussion, I'll explain the general framework. The general framework is a discussion of everyone on the topics. Yahli is going to give the general framework of the discussion that we're going to have, but the floor is for everyone. There are no designated speakers in this roundtable discussion. Do you want to come closer? Sure. Might be nicer for you. Especially sitting there in the dark, and might send Magda too.
I was waiting for that one.
Hey, it's my place.
The Polish place.
Yes.
She's the actual Polish. You're.
My kids are
edit that out of the video. But yeah, so Yahli, the floor is yours, please.
So, Ido kind of stole my introduction. There are two surprises here. Firstly, that this is not a round table.
Great.
The second is that you usually imagine three people sitting at a round table, but actually it's a few. So an important task here. So I'll just say maybe I'll take 5 minutes to introduce the topic, which is non-state actors during armed conflicts and counter-terrorism as part of the general theme of this workshop, which is balancing contradicting human rights obligations in armed conflicts and counter-terrorism. And I will raise several thoughts that I have on the subject, and then we'll for before discussing about any of these issues or some other aspect of it. So, at the stage, I think that there are some terms here that we need to discuss. The first is non-state actors, and it seems that in this workshop we often refer to non-state armed groups, but it includes a much broader set of non-state actors, technology companies, other non-state actors, so all are relevant for our discussion. And the second thing is, I think that the key question that was present in, I think, the two sessions that presented this roundtable is what is unique about non-state actors. And I think it's a challenging question, in several aspects. First is the descriptive, what is really different when it comes to non-state actors and contradicting human rights obligations. And there we can think about several things that appear to be a bit different. The first is, to what extent do non-state actors have human rights obligations at all? Well, this is, I guess that you are tired of discussing it, but obligation to talk about it roundtable. And the second is that counter-terrorism, which is a significant part of this workshop, applies mostly to cases where non-state actors are involved, right? If we have a conflict between two states, we rarely talk about counter-terrorism as part of the regulation. So it seems that this is unique to the present of non-state actors. And right, for every descriptive question or the normative question that is, even if there are differences, is there a justification for this differentiation between state actors and non-state actors? We heard in previous discussions about legitimacy, about compliance, and I must say that for a long time, I really suspect this issue of differentiation between state and non-state actors, especially because I think that we often have assumptions that are not necessarily unique to the non-state actors, right? So putting together compliance and non-state actors is something that is really not necessarily putting the idea of just versus unjust side to a conflict, putting the notion of even power differences is something that would easily change. Just think about Lebanon, for example, not from the Israeli versus Hezbollah conflict, but the internal difference between the Lebanese government and Hezbollah, who's more powerful, right? So I think that many notions that we tend to attach to this concept of non-state actor, we can question them to what extent they are accurate. And the second, maybe the next thing is that we need to break what's unique into different questions beyond this general questions about the capacity of applications. So I think when it comes to specific issues, we can think about places where we might suggest that there's something unique from a quality perspective of the rights in question, so that they are truly unique to non-state actors. So, for example, think about potential contradiction between the right to self-determination and other rights. This seems to me that it's often uniquely associated with non-state actors. They must be involved in all of it. So in many cases, there will be a prominent title and will be part, I guess, of some of the discussion tomorrow. But it was a preview.
It's complicated. It depends. It steals your presentation.
And in other cases, it might be a question of quantity, and here I would love to hear your thoughts. So we have a problem that is present in international armed conflicts, but it is even more present when this is an item. And a second issue of something that might be about non-state actors and contradicting human rights obligations relates to the actors. So who has the responsibility? We can imagine not necessarily contradicting obligations, but let's say obligations that co-apply to both the state and the non-state actor. Think about the right to health of the population in a war zone. You can assume that both the state party to the conflict and the non-state actor have human rights obligations towards the population. How should it be divided? I think it's a complicated question, an important one. And here again, we see that often we focus on the state actor when we talk about these actions, to what extent is it justified, maybe, and what are the potential solutions to have some kind of shared responsibility. And the third is, to what extent do we think that human rights obligations should apply equally, universally to all people that are involved in an armed conflict? So does a state have similar obligations towards its citizens and the citizens in an enemy territory? Maybe there are some obligations that are similar, and other obligations might be different. And think about, and it applies also internally. So think about free speech. It was one of the examples of expanding criminal responsibility when it comes to counterterrorism, for example. So should the state treat speech that is pro and against the state during an armed conflict exactly the same? I think that there is a strong tendency to suggest that there is, but it's accepted that in states they have right criminalization that relates to loyalty to the state, and in some aspect it's legitimate, maybe in other aspect it's more problematic. So to what extent do we think that during a conflict there are some notions of loyalty that can fall into this notion of, and it reminds me, right, we know that part of, for example, of the protection of POWs, we do not use them against, right? We cannot take them to be part of the war effort. And one of the main reasons, or one of the main explanations, is because we assume that people are loyal to their community. So to what extent do we think that it also applies to the notion of human rights, and how should we? And I guess that these are the main points that I thought about, and looking forward to a vibrant discussion.
Okay, let me vibrate. Going back, I've got lots of disparate thoughts about things that you said, but going back to you said it's boring to talk about do non-state actors have human rights obligations. So first of all, can we agree that we're talking about armed groups and not about preliminary question? Are we talking about armed groups, or are we because it's armed conflict, or are we talking about any non-state actors?
Are we talking about businesses? Any. Or any other.
Whatever, apparently whatever we want, but it's not your phrase. Okay. No, so going to organized armed groups, and the question is, it's obvious that they have, or it's boring to talk about whether they have human rights obligations. Maybe it's boring to talk about that, but it's actually not so obvious. So, I think in most of the literature that we see on that, Andrew Clapham, for example, who was like the guru, right? When you look at at least in the earlier writing, I'm not familiar with his very latest publication, maybe. Oh, sorry. So basically, it was all about IHL, which is the human rights version in armed conflict. But that doesn't answer our question. We know that they have human IHL obligations. We want to talk about hardcore human rights. Positive obligations under the right to health, for example. Like that would be a good example. There was never an answer to that. And then and I think if we look at it now, it's kind of boring to talk about it because it's kind of obvious that organized armed groups, at least the ones that have territorial effective control over territory, they have human rights obligations. But then when you look at why is it so obvious, so you see all kinds of special rapporteurs writing reports on that, and commissions of inquiry writing reports on that. So I remember doing research in the past. So there was something about the war between Israel, the second war in Lebanon, Israel-Hezbollah, really, that Hezbollah has obligations under human rights law. And there was something about excuse me for being very familiar with our specific conflict. So there was something about the war in Gaza in 2008. There was something about Hamas and Palestinian obligations. But over the years, there have been more of those commissions of inquiry and special rapporteurs, and they all take it to be almost obvious. And I'm thinking, give us 20 more years, and we will be teaching that this is customary international law. But when you look at where does this customary international law come from, this goes back to the issue of sources of law. It's because special rapporteurs say that it ought to be like that. Yeah, so I think this is the state of the law, which is extremely unsatisfactory. But that's my contribution. What else could it be?
What else if you assume that states are the ones that sign treaties, so you don't let non-state actors enter in that level to human rights treaties. The only way to do it is through customary international.
They're also excluded.
No, hold on. They're excluded from what?
To contribute to the creation or crystallization of customer international law. Because the International Law Commission saw this.
Okay. No, that's what I was going to say. In addition to treaty, you could argue, what about customary international law? That ought to be it if we are willing to include them in the first place. And I also said no. Yeah. So I'm not saying that there's anything wrong with that. I'm just saying this is not the most stable of basis, but it's not worse in other areas of international law. Fair enough.
Law at a certain point is built on error. It's
Exactly.
Everywhere in law, there's a certain point in which you get to a belief. A $20 bill is worth $20 and not a piece of paper simply because we believe it's worth money. So once there's an accepted convention, you can from that.
But anything can be law, just say it, repeat it enough times. I don't think that.
I don't think that we are the people that if we say very long enough, it becomes law. But
this is how it starts.
No, that's not serious.
If I can follow up on that, so yes, special procedure mechanisms write what they write. They're independent experts. That doesn't necessarily mean that their views are the views of the UN. The UN, at least when it comes to OHCHR and the Secretary General, mostly takes the view that when a non-state armed group either exercises effective control over territory or government-like functions, then they do have human rights obligations. The exact scope of those human rights obligations is still a little bit tricky for me, especially when it comes to negative versus positive obligations. But if we look at member states, it's a very, very different picture because, for example, the African group is very much in favor of talking about obligations of non-state actors. We are, as in the Western Europe and other group, very much not in favor. The only way in which they are willing to talk about or to engage non-state armed groups is as criminals. So in that sense, there's a very, very clear regional divide, which for me makes the customary international law argument currently a little bit tricky for a number of reasons. I was also,
but you didn't agree that in 20 years' time people are going to say, "Oh, maybe 40 years they've been saying that," and the fact that if you look at state views, and states can obligate non-state actors, so that will get lost somewhere.
I'm not sure it will, because if we look at even other things that should be less controversial than non-state armed groups, just the binding treaty on business and human rights. I'm not saying it's comatose. Maybe it's not comatose, but it's in a slumber, and the slumber is deep. And the same when it comes to any binding instrument that would impose these kinds of obligations. And even then, even when it comes to the Treaty on Business and Human Rights, it's not that it would directly impose obligations on businesses as things currently stand. So in that sense, maybe in 20 years, we will say, oh, of course, non-state actors have human rights obligations. This is extremely clear. But I'm not necessarily seeing a very clear road.
No, but okay, so there's a distinction. For organized armed groups, I'm talking about organized armed groups because for business, you're right. Nobody claims, not even the special procedures claim that they have binding obligations. At this point. Right.
It depends who you...
They should be we're talking about duties, not responsibilities, or maybe the other way around. But for organized armed groups, CEDAW, okay? CEDAW, which is a committee that monitors a binding treaty. Like you can't get around. I've got it somewhere here. They speak of the idea that I think that non-state that organized armed groups would have obligations. I think they limited it to peremptory notice or something. It kind of makes sense, but
it does. For me, there's two things on that. One, obviously, that. Businesses do not generally control territory, do not generally exercise government-like functions. We can discuss that in certain circumstances, but it's more likely to have that with non-state armed groups. At the same time, if we look at most of the jurisprudence of, the European Court of Human Rights, even the treaty bodies, they are still very clear, and most UN documents are also very clear that obviously the primary obligation, at least, is with member states. And if I think about cases where a territorial state's obligations have been considered adjusted, where a body would say, they only have the positive obligation to try to exert influence, to try to regain control and so on. The only cases when that was acknowledged, one was in situations when the non-state armed group was controlled by a state. If there is no state control, even the human rights mechanisms are very, very reluctant to say, oh, dear territorial state, we are less strict with you when it comes to the extent of your obligations.
Yes. So I was thinking about a specific example with respect to India and Taliban relations. Before that, my question, or something that I was pondering on, was at what point does this become a moot or an academic question, and whether they have obligations? Because, for instance, India, for the longest time since the US withdrew, had a policy that they will not engage with Taliban. But then they realized there's just no way to force them to comply with human rights obligations, protect the rights of women, and now they are engaging with them again by inviting them to meetings, etc., on the sidelines of committees. So I was just something I think.
I was about to say that at some point it stopped being a non-state actor and became.
But they still consider de facto government.
Exactly, and this is factual and
That's political.
But conceptually it fits, right? We engage with them once, we consider them for whatever reason to represent the state.
Yeah. Two points. The first one is on methodology, and the second one is more general about the diversity of non-state actors. On methodology, I do not see any contradiction between saying that it's still an exercise of customer identification of state practice and behaviorists, and saying that there are certain procedures, such as special procedures, having the International Law Commission or court judgment, that influence the way in which states are going to engage with it. They're going to react in different ways, and it might be that in 20 years they're actually going to agree, but it might be that they will not agree, and in which case the custom is not going to emerge. So it doesn't seem to me that there is any contradiction between accepting these two. And the second one is about this question of diversity of actors. I actually completely agree that the different types of actors that become prominent might influence the way in which we think about, for example, businesses affecting how we think of organized crime groups, or individuals and their civilization, especially in terms of digital technologies now, also impacting how we think of these. So to me, it's one and the same conversation, though of course it might be that regulation will go in different directions for each of them.
So a couple of things. First, it's extremely interesting, right? Not a boring question. It's just to discuss it. I meant that we discuss it, I guess, separately several times before, and there's no definite conclusion, and I'm not sure that we will solve the problem of whether non-state actors have human rights obligations, but maybe we'll convince each other. So at least from the way that I see it, and it goes back to the right, at the end, we have reality. I think that it comes close to it, right? We can engage in doctrinal debates all day long, but at the end of the day, we have areas in the world that are fully controlled by non-state actors, and they run daily life. And in terms of common sense vision of this reality, no one really thinks that they're not responsible for the life, for the education, for the health of the people that reside within these territories. And I would suggest that maybe we should rethink the way that we think about customary international law in a way that no state, right? So states resist the legitimacy of these actors. But
that's not the same as saying
they don't resist. They don't resist the obligation. They resist what they resist, and this is, I think, a bit nuanced. And it's a paper that I'm writing about a different topic about Yusuf Bellum, but it's the same. It's the same idea. They resist acknowledging that they have human rights, but obligations. But they believe that they have human rights obligations. So we have here two layers of the way of the law, right? One, the formal articulation of everything, right? So they say, let's go to the ad bellum example because it's easier, right? Ad bellum doesn't exist when it comes to state actors and states, right? But no, we will never find a state that kills a person that belongs to a non-state actor outside its territory, let's say in the high seas, and says, we did it because we don't have any ad bellum obligations here. We can do whatever we want, right? So they do believe that they can't just arbitrarily kill whoever they want. They do believe that there are obligations. It's just that they're so invested in delegitimizing these groups or not taking
but legitimacy in law
at least my point of view is that we should be more careful about, right, we have this tendency to rely on statements when we think about customary international law, and I think that this is one area when we should be more cautious than just looking at what people say. And the second thing here is that we do have examples that are not directly human rights related, but close to it. So think about crimes against humanity. What are crimes against humanity? Right, so we can have different versions of it. One of them is like gross violations of human rights. No one really disagrees with the Kenya decision that suggests that non-state actors can commit crimes against humanity. What does it mean? Do they have human rights obligations? Maybe it's a way to think about it, right? And the last thing is that if we are part of this mixing IHL and human rights, like really intensely, right? Then if you don't accept human rights obligations of non-state actors, you really go against this notion of equality of belligerents or the way to have this notion that we want to have two parties to a conflict with similar obligations in order to regulate it as best as possible. And there are various tools that you can reach the same conclusion, right? Because a significant part of this relationship is based on interpretations of IHL in which we include human rights interpretations, and you can easily do the same for non-state actors. So we have fair trial obligations, we have nothing explicit in IHL about it. We can say, well, we'll enter everything that we know about it from human rights, and it will apply to non-state actors, not because of their direct obligations for human rights.
Because of IHL.
Right. So this was
just on the not saying they have human rights obligations, but thinking they have human rights obligations. So a member state who argues against human rights obligations of non-state armed groups would say, in these situations, when they perpetrate conduct that would amount to crimes against humanity or other crimes, they would say, obviously, that you need to deal with them through criminal law. It doesn't mean that they have human rights obligations. They can still commit crimes, and you need to engage them through criminal law, not through any human rights obligations. However, I think the point about the equality of belligerents is a very good one, because when it comes to anything beyond the very skeletal obligations in non-international armed conflict, we are really just dancing around a very, very hot fire when it comes to what can and should be expected from non-state armed groups party to the conflict. So I think that is definitely something that people have tried to, and that's worth exploring quite a bit more in detail.
You know?
Yeah. Follow up to Christina's, I think there is a big question of whether or not we're talking about positive or negative rights with regard to the criminal aspects of it, because it's a question of what they are violating, what they should be protecting of, and there's a big difference of how we address that, and that leads me to another point of, I think if we look at how we would imagine things in semi-perfect world, then we said definitely non-state actors, non-state armed groups would have human rights obligation, and they would have them to the fullest extent. They would have an obligation to the education and freedom of expression and everything. And of course, but even if we give them all of that obligation, it comes to the question of the theoretical versus the practice. So what? We give them all the rights, and they violate them. I mean, in most cases, they are considered to be a criminal activity to begin with. So, and we're not talking about, if we're talking about general human rights violation, not about the extreme human rights violation, which go to crimes against humanity. If we leave it at the general level, then, well, we're going to take them what kind of sanction can we have towards them that will help us to implement that human rights obligations towards them. And it ends up with the question of, okay, they do have the right. Let's jump 20 years from now. It's customary. They have human rights violation.
They're no worse than
They have
states.
human rights.
I agree with
but
you.
states can stand before the treaty committees. They stand before the treaty committee. They implement or not. They adhere to it or not. That's one question. But they do stand there. They appear that they are signatory to the treaties. Non-state actors are nothing in international
It sounds
law.
like you have two different arguments here.
I have more than two.
Like when it comes to the last point, because the first I agree with you. The first was like, what difference does it make if they violate the law? And in this sense, I think that again, I think that it's not necessarily clear that non-state actors violate the law more than states. The second version, I think, it has more challenging issue is that we don't have a sufficient mechanism to address the
human rights violations.
Of human rights violations, because at least when it comes to the institutional aspect of human rights law, this is all about states. And I tend to agree, at least with when it comes, and the answer will be to solve it, right? Like if it will be, if we will be able to explicitly acknowledge this,
so the road
obligations, we will.
So the road from point A to point B of no responsibility to full responsibility is that mechanism. Probably part of it.
I think that we are a bit underappreciating the expressive value of the law. Meaning law does much work outside of institutions. It has an effect on behavior. It's never perfect. There are always violators, but there is power to the law by the sense that most of us believe in the norm, and then when we violate it and being reprimanded for it, it has an effect. Never perfect, but it has an effect. And I think that therefore the stage of saying, okay, a non-state actor has the duty, and by that erasing the option of that non-state actor saying, I'm not obligated to that. Why are you saying? And forcing it to justify, okay, why you've done that and so on. It has power, even without mechanism. How much power does it has? It varies from one actor to another, depending most of the time on that non-state actor's allies. If its allies care about human rights, the argument would carry weight. If its allies do not care about human rights, the argument would not carry weight.
I think I have trouble with the fact that the discussion often treats non-state actors as one and the same. And I think that to say non-state actors have human rights obligations is very problematic for me. And I think this has emerged in the discussion that they had. So, for example, let's say that terrorist groups have human rights obligations. So what? I mean, the very aim of terrorism is to terrorize humans, to use them as objects in order to achieve political aims. So if let's say that Hamas has human rights obligations and they have to protect hostages, for example, they're not going to do that. We know that. I mean, the aim of taking hostages was exactly to terrorize the population of Israel to achieve their aims. And I think it's a negative approach to say that they do have human rights obligations, because in some instances, this is something like absolving states from the responsibility to do something, because the groups have human rights obligations and they have to protect these human rights. Then the other issue is what Christina mentioned. I mean, when we talk about business and human rights, for example, it's not about the non-state actor. It's about how the states regulate the activities of these actors. So we're going back to states. So let's say businesses or shipping companies, they have a code of conduct or they have some human rights standards, but you expect states to actually inspect this in order to make sure that these are implemented. So we go back to states. And then in the other scenarios you mentioned, for example, have a non-state actor that occupies or has control over a territory and they do day-to-day activities, hospitals, and schools, and so on and so forth. Sometimes, even in these cases, it's difficult for us to accept that they have human rights obligations. So I go back to the example of Yemen, which I studied a bit more recently. And the official government of Yemen will never accept that Houthis actually have human rights obligations because it goes back to the matter of legitimacy. I mean, they don't want to accept that they exercise effective control. So it's very difficult for them to say that they do have human rights obligations. So there are many different issues with the different non-state actors that we're discussing. And this is my problem here. I mean, it's just saying that they have human rights obligations. It's challenging both in theory and in practice.
Just to follow up on that, actually, for me, one of the very difficult aspects, even if we happen to have a non-state actor that would want to comply with obligations under human rights, we think as human rights compliance, so much of it is about rule of law institutions, about being able to say that something is grounded in law, that you have an entity that can pass a law that is, foreseeable, that has safeguards. When can a non-state actor have a lawfully established tribunal, et cetera, et cetera? And I think this is linked to the points just made about the fact that when it comes to non-state armed groups, we do not have a state that may want to enforce those duties or obligations like we would ideally have in the case of business enterprises. So there is the non-state armed group who has to set up all this parallel structures, basically a parallel rule of law structure, which would be very unlikely. So because of that, for me, I can see compliance with certain human rights or limited compliance with human rights obligations, but it would be difficult to have the full rule of law shebang that we normally would have and expect from a state.
So just before going to to some extent, it only convinced me to hold the opposite approach to some extent, right? Because I think that we can raise similar arguments about IHL, right? Why do IHL apply to these groups if they are not willing to comply? So, I think that part of the answer is because pointing a finger and saying you are in violation of the law is extremely important. This is how we think about it. So it's both incentivize these actors to follow the law, and also it allows us to have correct allocation of responsibility for what's going on the ground. And I think that, especially when it comes to human rights, again, we do not. The thing is that in international law, and it's a puzzle that I think about it all the time. In international law, we run away from this notion of bad states. Right? We don't have bad states. Is Russia a bad state? Is Israel a bad state? Is the US a bad state? Is India a bad state? Do we have this, like we have individual opinions, right? But we don't have this notion of bad states. We do everything that we can to ignore it in order to have this kind of shared version of international law where each state have the same, at least, right, ostensibly the same ability to shape the law. And this is why we have this fake thing that we call customary law, where we can give more power to some positions without explicitly saying that we care about some positions more than others. But when it comes to non-state actors, suddenly we have bad actors. And there might be some non-state armed groups that violate the law, that don't have, but we have states that are exactly the same. They don't care about international law, they violate it all the time. We don't just give up on this notion. And the reason is just like domestic law. We know that there are criminals. They're part of our regulation. They're part of the obligations that we share. And in this sense, I agree that we need to differentiate between different actors, non-state actors, but it comes to capacity and what we expect of them. But in some ways, we do the same with states. So think about extraterritorial human rights obligations. A state is not responsible for the education in state B, but it might be responsible for the lives of the people there if it just bombed everything. Right? Not everything, because then it will be international problem. But assuming in the high seas, just a boat with individuals, and Marco will be here tomorrow, and he's like the example of the supporter of like universal. But so we can think about a kind of functional approach to human rights, and it makes sense, right? So if they control territory, they have these and these human rights obligations that they don't do. And if they don't have the capacity, so for example, to have fair trials, they're not allowed to do it, right? So this is part of their obligation. But if you think about those non-state actors that you've mentioned, and we can go to many different examples, right? From Hamas to in Syria, right? We have many areas in Syria that is in full control of the Kurds or the Free Syrian Army, and they have schools, they have laws, they have courts, they have everything. They have legislation, right? Internal legislation. So in what way don't we want to expect them to have responsibility for these rights?
Just on this, I really like this point because my own view is if you advance the argument that non-state actors, especially armed groups, they don't have human rights obligations, politically it's problematic because it fuels the argument from the other side that whatever they are doing, it's completely fine. It's not under the paradigm of law. So politically it's problematic, let alone the legal obligation aside. Politically and at a more deeper level, philosophically, I think it's problematic to advance that view in terms of the perception. Yeah.
I tend to agree with
you.
Okay, a couple of things. So one is this idea of legitimacy and law, and I'll be very formalistic. There's a distinction between these two things, and I think after the recent war in Gaza started, Ido and I were both involved in drafting some papers that dealt with the responsibility of Hamas and other groups for the welfare of the hostages. And we referred to organized armed groups. And there was a lot of criticism. Why do you say organized armed groups? These are terrorist groups. And we said, well, under international law, terrorist groups are not a thing. Organized armed groups are, and there's law that applies to them. And we didn't tell them that there's customary international law that doesn't really apply. And it was really, there was something there that was really difficult. And as a lawyer, I didn't think that the fact that I'm acknowledging that they're organized and they're armed gives them any political legitimacy. But this was a conversation between and to explain that there's the political element and the legal element are very different. And this, so a couple of other things. One, I'm not concerned at all with the issue of equality of arms in armed conflict, because it's the equality of arms and the laws of armed conflict. It doesn't mean equality in everything else. It's IAGL that needs to apply equally to Hamas and Israel, or Hezbollah and the Lebanese government for that matter, or whoever, and not necessarily everything else. Now you're right that you can stick more or less everything into IAGL, which makes the argument almost moot, but not, because when we come to positive health obligations, then there's a difference. But I think that underlying all of this, the idea that we speak of non-state actors as if they're all the same, not only are terrorist groups the ones that by definition violate human rights, so it sounds, as soon as you talk about organized armed groups that have control over territory, the issue is not that they're organized armed groups, it's that they have control over territory. They're de facto entities. So actually, let's think about the TRNC, Northern Cyprus. we were talking about their human rights obligations, and they don't need to, and they're not in organized armed groups for, like, I don't think.
No, to some extent.
Yeah, but non-state actors.
Well, Taiwan.
Yes,
Taiwan does not claim it's a state. Nobody would say.
And yeah, but Taiwan is the actor that we all like, and the TRNC are kind of a bad actor for some. So let's take that as an example, because maybe people will think of them as a bad actor. So it's a good example. And I think the bad actor, good actor division actually doesn't work. But if we think of, so the whole issue of human rights obligations, it's not of organized armed groups, it's of de facto entities. And going back to Hamas, the obligations of Hamas towards its population and the obligations of Hamas towards the hostages and the hostages that are being held by the jihad, which is another organized armed group. It's not because Hamas is an organized armed group, it's because they have control over territory. So the whole discussion about organized armed groups and human rights law is redundant. Or not redundant.
I want to disagree with Sophia and
No, but if you use non-state actors instead of organized armed groups.
No, I never say non-state actors. Non-state actors are everything that is not state.
Exactly. So
I'm talking about entities that have control over territory. What's called de facto entities or de facto states. Okay?
And they're not states, right?
They're not states.
So they're not state actors.
Yeah, but that's
so they fall under our roundtable. Topic, which is,
No, they're totally honest people. I'm just saying that to say non-state actors and mean organized armed groups, and sometimes mean it, sometimes not. It's confusing. And the whole human rights obligations is not of organized armed groups, but of de facto entities. And one final thing
but I do have a question, right? Because we have, if we go back to this like functional idea of human rights, then we can easily think that organized armed groups have human rights obligations, at least towards their own combatants, right? So, right, they're not in charge, because we often squeeze it into, why?
Why would this be such an obvious category different from the others?
I'm saying that there are human rights.
Does the government have human rights obligations towards its military?
Yes.
Hold on. Obligations towards them. Does it have human rights obligations that revolve from its military function rather than from the fact that it's a government that has control over it?
Okay, so here's the thing, okay? We have, going back to extraterritorial application of human rights, right? We know
it would be a function over over a person,
right? So we know that the two categories are effective control over territory and effective control, right, over a person, or like, and it has a reason.
It's got nothing to do with IHL.
It has nothing to do with IHL, but an organized armed group usually means that it has maybe similar control towards its members. And if we think theoretically about why these two examples give rise to human rights obligation, it makes sense, right? Because you have aspects of control that lead to certain obligations that make sense if we look at the world and say, what are the responsibilities of those who have this type of control over other people? So if you have a control over territory, you will have a significant number of human rights obligations that include every aspect of life. But if you have a control over a person, right, then there are clear human rights, the obligation that you have responsibility.
And organized,
and we can apply the same logic to the control of at least some organized armed groups of all members or
an organized armed group that has no territorial control. To argue, somehow I'm thinking Jihad Islam, Islamic Jihad. Do they have human rights obligations towards their fighters outside Gaza? The question is so hypothetical that I can't even begin to think about it, but I'm not sure that it's obviously yes.
Sending a terrorist, a suicide bomber to...
Now you're gonna stop repeat prayers? With me you're gonna stop repeat prayers?
It's just, it's a challenging task to choose between the two of you. It's like,
Why all of
I was just wondering if the criterion is a question of control, and I very much agree around looking at control. What does that tell us about the control exercised by other types of non-state actors, such as digital intermediaries? So how would we think about us having our freedom of speech that is for all intents and purposes regulated within the social companies that we actually express it on? So is there a question of control that is really territorial in nature? Or is this something, a more general understanding of control over specific rights in specific contracts through specific actions?
Can I phrase it in a more general way? To what extent the standards with the trigger applicability of human rights obligations developed within the context of states, classic orthodox state-based framework can be transposed into different type of actors which differ greatly. I think these are examples where this is such a major difference.
Is it? I mean, this is my question. Is it such a major difference? Or are there just different ways of thinking about control over specific rights?
I would say that it gets a little more complicated than that. And I have to say, I've written an article that dealt with this and had an argument and then decided it was not a good one. I'm not going to argue anymore. If you apply the human rights,
Still published.
oh no, I thought you write something and then years later you realize it was rubbish, but it's published. Yes. So if you assume that non-states of various kinds can have human rights obligations, so we know that human rights can be limited for various purposes, right? So presumably, and sometimes you need to limit human rights in order to ensure important interest or. So would you also apply that element? For example, a state may limit rights in order to ensure national security. Like basic, right? Okay. So does a de facto entity also have the right to limit rights in order to ensure its national security when it doesn't have the right to national security because it's not a state? I don't know. But if you start this game, then everything becomes completely malleable because you can argue anything in any direction. I think it's not an answer to your question. The answer to your question is that can we human rights be divisible according to the specific actor, or are not divisible but have different aspects, or with its control necessarily territorial control, or maybe it should be a little more functional. Human rights should be functional. So depending on your function, that's where the obligations are. But then that would also dictate the limitations, and then the whole thing becomes completely out of control.
But we kind of done it before.
What?
We kind of done it before. It's been done before. It was the entire conversation was very similar when there was a question of whether or not international organizations, which do not have territory can have different types of obligations. So it's not as groundbreaking as it might initially seems like. Was it the entire mutatis mutandis approach, right?
Yeah.
I'm not saying that it's not difficult. I'm saying
organizations have human rights. They don't have do they have human rights obligations?
They do in certain circumstances.
Zero.
I wanted to disagree with Sophia and Yael and agree with you, but now I feel completely different after. No. So let him first.
In general, third parties have a human rights obligation, but the problem, when there is a violation, if you want to go to the court, third parties are not part of the conventions. And if I consider the position of the Inter-American Court of Human Rights, first to, in the case that is called mosquito divers, first to transnational corporations, the court says, yes, it's the obligation of the states to respect human rights. Secondly, he says, third parties, state cannot be responsible for the act that third parties are responsible for. And the court says it, in fine, that it's the responsibility of the state to guarantee the right of the people. That means you find a transnational corporation that is bigger than the state, and the court asks you, ask the state to control that transnational corporation that has a lot of money. It's the same for the group for the group that you talk about. maybe they can be more powerful than the state. They have a lot of gun. I know a lot of guns that they have a lot of guns that are more powerful than the police. And if you seize the court will say that, yes, your right is your victim of human rights violation is the responsibility of the state to get your right, or the one who is really responsible for the right violation. The state cannot fight, cannot do anything. That's the problem.
So Sophia said that we have different kinds of non-state armed groups.
No, non-state actors.
Non-state actors, but even within non-state armed group, you imply that there are different categories. And Yael went with it and focused on one specific category of non-state armed group, the one that controls the territory. And my argument, no, you didn't say that. Let's talk about the factor that is and so on.
The emerging practice always relates to the ones that have territorial control. In other words, it's actually talking about the element that's not the armed element that's important. It's the de facto control.
But the thing is, there's a spectrum here. On the one side of the spectrum, like on one extreme, we have Taiwan, the good boy. It is a state for all intent. Like it looks like a state. It's a duck that refuses to acknowledge that it's a duck.
Right.
And on
the acknowledge it's a duck.
Sorry?
We refuse to acknowledge it's a duck.
Yeah,
no, but it's not a state. It's not a situation. It's not a situation.
They started to quack.
But even before they quack, it was clear that they are quacking inside. So we have Taiwan on the other side, on one side, and you have this terrorist organization.
Jihad on the other. No territorial control.
And in between, you have this very extensive spectrum that I really don't know where to put the cutoff line, because Hezbollah is a non-state armed group that does not control a territory, but is significantly involved within a state's government. So does it have human rights?
It's the outlier. It's like discussing what's the state and taking Palestine as an example.
No, but my point is that in the entity of a non-state armed group is a fuzzy entity. It includes a spectrum that I really don't know where to put the cutoff line, and therefore either you say, okay, they have human rights obligations. Once they do have an effective, I don't like the word control, but effective influence on the human rights of individuals, or they do not. You need to pick one of them, but to try to classify it and cut it, you simply multiply the problem of saying, okay, whether it's a group that we store with human rights obligation, to start having the arguments of which classes and so on, and it would be a never-ending argument of where are the cutoff lines.
So before moving to Idor, I will just say that we spent currently about an hour on the boring question out of the 5 questions. And
it didn't include elements from the other issues.
It was really exciting, but I think that A, we can continue discussing if you want. And B, I think that Barnabas raised in a way the second element, or at least one of the elements, which is if there are 2 actors with obligations, assuming that we can imagine this reality, we can somehow agree. So how exactly do we want to allocate the responsibility of these obligations? To what extent these are contradicting obligations? To what extent insisting that both actors have obligations in a way can allow incentivize them maybe to violate the law because there's others who are responsible for it. If we want to have anything to say about it, we can return to the whether or not state actors have obligations, but no.
I'm not sure that I'm jumping into that point, but I do want to offer another layer of discussion that might be relevant and might be interesting to hear some of the other perspectives here, and that's the issue of technology. And the entire issue of technology, we've seen it outside of armed conflicts for sure, but with regard to hate speech and the responsibility of non-state actors like Facebook, Twitter, and other companies that have some responsibility and have acknowledged that level of responsibility with regard to hate speech on their platforms and freedom of expressions on their platforms. And we've seen Facebook establishing an entire mechanism to analyze that. And then you can definitely argue that it has some state aspect to it because they didn't do it because of their goodwill. They did it in order to avoid state pressure, but they have enough power to stand in front of the states and tell them, this is what we're going to do. If you want to fight with us about that, we're going to have a problem and you're going to probably, both of us are going to lose at the end of it. So this is the mechanism we're going to choose. This is how we're going to overview the issue. And this is our solution. So if we take that from outside of the notion of the framework of armed conflict and counterterrorism, and we can also take it into that framework, hate speech definitely can be within that framework of terrorism, at least, and counterterrorism issue. But again, we take it into that framework if we acknowledge that they have some responsibility. Then, okay, so if they have some control over information, they have some control over someone's cloud and then data. And if other companies are developing new types of weapons, are we going to consider that as part of IHL or part of human rights obligations because of what could happen from the use of that weapon directly by the companies, which is an option, or if they sell it to a state later on. Right now, it's not. We could argue question of Article 36 of Adhesion Protocol 1, but you could argue at the same time this is a state obligation and not a non-state actor obligation. So there are several questions that are within the layer of technology, and I'm just putting it out there, not necessarily answering anything out there.
I mean, precisely on this point, and this is where my example was coming from in terms of social media companies, and I think the question to me is where would that obligation derive from? Because I think when they say we have responsibility, they don't have direct obligations under international human rights or any other regime. They mean something more softer, the way in which the Yahli principles speak of responsibilities. But there are ways in which we can think about this, and one is precisely what you're saying. We actually take a specific notion and we say human rights obligations attached to specific metrics, such as a particular type of control, or specific identifiers that would be like a state. And then we attach that, but that has implications because whatever non-state actor would lead those, that would mean that the obligations would apply to them. So it wouldn't be about the group or about this, it will be about a specific metric of control. And then the other way in which we can think of this, and I also wrote a very important paper 9 years ago on this topic, so we're in the same boat on this. But it was also about what their statements mean in terms of their own commitments. Can they actually bind themselves to specific types of international obligations by saying that they have those responsibilities? But to me, all of that is a question, as you said at the very beginning, of methodology. Yeah, it's a question of methodology, of identifying the trigger for obligations and human rights.
But here, maybe somehow I feel a bit different about some of the things that I've said, because I'm thinking about these companies. And I just want to raise some aspect of the problematic nature of this type of obligations. Think about content moderation. Think about all of these obligations in order to protect human rights in this realm. And the question is, to what extent do we trust these companies to do it properly? And what is the source of the legitimacy to do it? So if we say that they have human rights obligations, in the sense maybe they need to protect against hate speech and so on, do we trust? And the interesting thing here, just like your approach towards the Supreme Court, you have strong theoretical perspective, and then the reality. You have some appointments that might change your perception. The same about how the government works and so on. And I think that we have an amazing example when it comes to social media. So I read a paper by a good friend and a great scholar who praised the engagement of these giant techs in world affairs, right? So look, right, they suspended the account of whoever, right? And a person that is not controlling the world, probably. But, and right, there's lots of promise that Twitter enters into foreign relations. And somehow, at one point, there's a switch in who owns the company, and the entire approach changes. And to what extent, right, can we have like a strong positions that are not based on contemporary reality regarding these companies? I think it's a huge challenge, and it all kind of, right. We will always have, or at least for the foreseeable future, we have to deal with the huge problem that these companies have so much power, right? But the answer, I find it really tricky, and I won't solve it here.
Oh, no.
We still have 15 minutes.
Joining the two of you with someone who has written some unfortunate papers on this issue. So on the metrics that you mentioned, for me, one of the components of the metrics is that the company in question provides services that are of a public interest nature. Because one of the reasons why social media companies arguably may have human rights responsibilities / obligations is because of the roles that that they play and the implications of you not having access to those services and to those platforms. Because at this point, not being banned from all social media actually has pretty serious implications on how you can communicate, how you can express yourself, and so on and so forth. So for me, the public interest nature of the services would be one component of the metrics when we decide on these obligations. And when
what do you mean by this? What do you mean by public interest?
So for me, sorry, I think I'm losing my voice, but when it comes to Facebook, Meta, Twitter, Instagram, all of these, the way in which they're used for political public interest discussions.
They're the platform for expression.
Yes,
they're like public squares.
Exactly. It's basically the public, the equivalent of the public square. They're also used by governments to communicate. If you have a natural catastrophe, if you have an armed conflict, if something happens, the government may communicate via social media that you need to evacuate, that you need to do this or that. So again, not having access to those services may come with quite serious human rights implications on your freedom of expression, right to privacy, even right to security, and so on and so forth. So that's what I mean by public interest, and that's why I'm saying that when member states want these companies to basically police and adjudicate and do all of those things when it comes to unlawful, including terrorist content, they are outsourcing public interest tasks to these platforms, but without the proper safeguards and without the proper oversight. And for me, for example, when it comes to, and that's where I see a difference between a de facto government and the social media company. For me, if the social media company looks at legitimate aims under human rights, under which they can decide to, for example, censor content, they have to look at the legitimate aims that are sort of in the interest of, for example, the state under which jurisdiction they are for the purposes of that transaction. They cannot say that it's my, public safety that I'm looking at when I decide to censor or remove content. I don't think that they can have this, my own security, my own safety, my own morals, etc., etc. It needs to be, if they are doing these public interest tasks, it needs to be grounded in public interest interpretation of these values.
But it wouldn't be in the interest of the state where they're registered. It would be international law.
But for me, that's the only way to do it is international law, because otherwise the jurisdictional complexities will have you completely lost. We still have issues with, rule of law, provided by law, all of these aspects where I do think that we would need a very different ways of state business cooperation. Mm-hmm. And the only way to do it is, as you say, if you have international standards, because otherwise, and that's one of the things that we discuss all the time when it comes to, for example, terrorism and terrorist content. You're a social media platform. You're active in, 130 countries. Those 130 countries have 130 definitions of terrorism. Good luck to you in trying to figure out how to moderate your content. And it's absolutely impossible unless we come up with more universal standards for content regulation.
There was a reason, though, that we didn't succeed in having one definition, right? So we just have this similar problem. We just need to solve the problem of defining terrorism.
Exactly, we need to revive the process in the Sixth Committee.
Yeah. Yeah. I'm thinking that 20 years ago, or whenever Philip Alston wrote an article called "The Not a Cat Syndrome," where he argued, I don't remember what the cat story syndrome thing was, what the origin was, but what he said was, we say non-state actors where all they have in common is that they're not state, but there's the whole spectrum. Mm-hmm. And I think what you're suggesting is, so instead we're now dividing them when we have different categories. Come to my seminar and then give the presentation that undermines the whole system, because you're suggesting to basically, instead of making these divisions, let's acknowledge that there's the whole spectrum. And then when you didn't, and the what follows is from this, which you didn't say, so you're not responsible for that, is possibly that the idea is that human rights obligations might be also in some way they would be along the spectrum where they would be commensurate with the obligations would be commensurate with the capacity or the powers. And I think it kind of goes to what Barnabas was saying. And I think what the answer that we give is that states are responsible for enforcing the law on the corporations, or at least trying to. And all they have is a due diligence obligations. They might not succeed, but they need to try, and they need to do whatever they can within their capacity. So it's the idea that you do what you can within your powers. And then everything is just one big spectrum of human rights obligations, but it doesn't exempt us from the basic question of saying, oh, so we are expanding human rights beyond states? If the answer to that's still a binary, either we do or we don't. If we do, then the content of human rights would be like the spectrum. But if we don't, then we don't. Then obligations remain with the state. It's now that's what we need to resolve in the next 15
7.
Yeah, 7.
Oh, okay. Oh.
The spectrum is smaller.
And one more thing. One more thing about social media companies making the decisions, and I think what's happening now is that there's Meta with the oversight board. It's not an example. That's the single case. Mm-hmm. And I think their decisions on what is included within freedom of speech and things like that it's a matter of time, if it hasn't already happened, for this to feed into international law. More like they claim to be working in accordance with international law as they understand it. How long is it going to take before the Human Rights Committee?
That sounds like a state already.
Yeah.
De facto authority.
Exactly. How long is it going to be before human rights bodies, like treaty bodies, for example, incorporate that as part of their own practice? I don't know.
So that's already
what I was.
They have that power is enough. They don't need immunity.
So it depends, but it depends on trust in these institutions, right? So I think that again,
or acknowledgement of power.
Human rights bodies like those who run social media companies at a certain point in time, they're likely to adopt their positions, while in different times they will not. And we have here a problem that will remain forever, which is we don't trust states and we don't trust these companies, and someone needs to decide about it, and we need to choose. And it's a hard choice, because sometimes we like the current government, sometimes we hate it, and sometimes we like those who run these companies, and sometimes we don't. And if we're totally honest, I think that intellectual great theoretical positions on these issues are dependent to a large extent on the basic question of who do we trust. Maybe in a certain moment, maybe for a longer period.
Well, the government...
Because or we can have a position that no one should ever moderate anything, right? Like totally free speech kind of.
That's not a non-decision. That's a decision.
It's a decision. No, I'm saying it's one of the alternatives.
We don't trust government. We don't. The whole point, at least in democratic regimes, it's not about trusting the government. We don't need to trust it. We choose it, and therefore we realize that we might not be happy with a certain decision, but we accept the rules. We accept the game, the rules of the game, and we know that we can change the government if we're not happy with what it does. We don't have that potential when it comes to private companies.
Well, the market will drive them out, or something like this. We will leave X and go to Blue Sky. Whatever.
Which I call Bluesky until I realize.
Right? So at least theoretically we have like all of the international Twitter left it towards Blue Sky or whatever.
But it's not the same constituency.
Okay, so we're gonna do the most popular thing ever in a workshop, and we'll say it was an amazing discussion, and we concluded 4 minutes early. So best case scenario. And no, it's enough for 4 minutes of like administrative.
4 minutes.
We actually.
Yeah.